Thank you very much, Nicolas, and good morning, good afternoon, and good evening to all of you. And a very warm welcome to this panel on cross-border and multinational mergers, the impact on development. There are many interesting questions to be raised with respect to cross-border mergers in developing countries. Among them is what is the economic impact of cross-border mergers on competition in developing countries, whether competition authorities in developing countries have the means necessary to assess transnational mergers from the point of view of threshold, nexus, resources, filing fees, etc. Whether there is sufficient formal or informal cooperation and exchange of information between competition authorities in developed jurisdiction and competition authorities in developing countries to review those mergers, and whether the difference in legal systems make this cooperation difficult or unable to proceed. So how much cooperation actually takes place, both on the substantive analysis and on the remedies, is of interest. Another question is whether there is a need to change the merger control regime of cross-border mergers to adapt to different systems. And this is raised, among other things, because we are all faced with some global mergers in the, for example, in the internet, in the high-tech sector, in the digital sector, where we have the same issues which are dealt with by a great many competition authorities, both in the developed and in the developing world. Finally, one of the specificities in a number of developing countries of merger control, but not only of developing countries, also of some developed countries, is the inclusion of public interest consideration in merger control, and what role should they play, how are they enforced, is of course also a topic of interest. Now, to discuss these issues, we have an excellent and very diversified panel today, and I want to briefly introduce the panelists. First panelist is Mondo Mazwai, who is the chairperson of the Competition Tribunal of South Africa in Pretoria. Next is Georgiana Pop, who is global lead for markets and competition policy at the World Bank in Washington. Next is Gönenç Gürkaynak, who is a partner and I think the founder of ELIG Gürkaynak, at law in Istanbul, and a very well-known lawyer in competition matters. And finally, we have Patrick Hubert, who is a partner at Orrick in Paris, France, but he's also the former general counsel of the French Competition Authority, and therefore he's had some experience as well as an enforcer. Let me now turn to Gönenç to talk also about how the timing of the merger review, when we have cases of multi-jurisdictional merger review, how that plays and whether that leads to a difficulty in particular for developing countries. Gönenç?
Thank you. Hi, can you hear me properly?
Yes, yes.
Good. So the timing issue is quite critical in the sense that the more agencies look into a matter, the more important the choreography of the whole matter becomes. And I would say that especially the waiting behavior of some of the emerging markets authorities is quite concerning in the sense that there is a catch-22. Very many agencies are waiting for the signal or the ultimate decision of more sophisticated agencies or more rooted, more established agencies. And then coming up with proper closing mechanics obviously becomes a very tricky matter because far into the review timing of the transaction on a global grid, you're still looking at very many agencies blinking in the radar screen as not having been resolved. And once some agencies come up with their decisions, suddenly all of them, one by one, start providing their decisions, which in turn obviously means that it's leading to a problem for closing mechanics. It may be an idea to perhaps do in some of the more nascent markets the notification a little later, so that the locomotive countries can take the lead comfortably. But then that leads to other concerns, especially the fact that some of the emerging market authorities may become hold-up jurisdictions. Luckily, the jurisdiction that I'm operating in, which is the Republic of Turkey, when we're doing merger control filings, we're looking at a sophisticated agency. So they have been doing their enforcement for more than 20 years now. And while it is an emerging market in the economical sense, the Turkish Competition Authority has its own policy preferences, and it does have its own gravitas as well. We do about 85 to 100 notifications every year. And I think the bigger problem in a country like Turkey, and there are many other countries like that, is that there is a little too much of notification going on, in the sense that joint ventures that have nothing to do with the Turkish jurisdiction also get caught. And this is not an only Turkish story. There are a lot of other emerging market authorities that are receiving notifications where you could question the reason why that notification is being made. A structural link between the joint venture partners is being offered as an issue, and there are some explanations for it. That's fine. But ultimately, this is also turning into a timing issue, because very frequently countries wake up to the fact that, or rather entities that are coming up with the transaction are waking up to the fact that this is notifiable a little too late, because it's such a remote connection. I mean, if you're talking about a joint venture for mining in Chile or a railroad pavement in Siberia, it just doesn't come natural to the parties of the transaction that this may have to be notified in Turkey or in some other countries. So there is also that type of a timing problem as well, a late rising kind of an issue. And going back to the filing fee matter that Frédéric has mentioned, this sometimes relaxes the authorities a little too much about them being a little overbroad, in the sense that some of these agencies do not use a filing fee. For example, in Turkey, there is no filing fee. So then these agencies do take the position that it is their workload, and maybe they're overexpansive in their interpretation, but then what's the harm? Whereas it should be explained, obviously, that a filing fee is only one prong of that analysis, and handling of timings and ensuring that transactions happen smoothly, and transaction costs, these still are on the table.
Thank you very much, Gönenç. So let me now turn to Gönenç to talk about another dimension, complicated dimension, which is the efficiencies in mergers. Gönenç.
Thank you. Again, to check, can you hear me?
Yes.
Perfect. So the efficiencies matter, and particularly dynamic efficiencies matter, is gaining importance in the sense that we may, in a decade or so, look back at this particular period of time that we're in and reflect on it and say, wow, we were really paying a lot of lip service to innovation, but we weren't truly integrating it in the merger control analysis after all. What I'm trying to say is that there is an evolution of the term innovation, and there is an evolution of the human understanding of why innovation is so critical in economic growth and advancement. And at the moment, it seems like everyone is talking about innovation and dynamic efficiencies, and all agencies are particularly keen on making sure that they are keeping all of their enforcement priorities vigilant about this. But at the same time, we are seeing a bit of a one-sided type of approach, which is that in terms of innovation being an issue of merger control analysis, basically it is only used to articulate concerns, and it is very, very rarely used to recognize a defense. So if there were to be any question marks about distributive efficiencies or cost efficiencies, it is almost impossible for the defense counsel, for the notifying parties to invoke the innovative efficiency issues and do away with the other worries. Whereas if competition authorities were to look at, say, the pipeline and diagnose an innovative efficiency concern, then they're sure enough going to make it an issue, as they did in, say, Dow DuPont, for example. And suddenly this is becoming very calculable and very articulable as a concern. This all means that at the moment, the more mature and established competition agencies of the world are using innovation only as a concern, but are not accepting it much as a defense. What does that mean for the emerging markets? It means one of two things. Either the emerging markets are also going to jump on the bandwagon, and they're going to come up with the same leaps of faith, and they are more prone, actually, to come up with those kinds of leaps of faith because they have less administrative capability in terms of economic analysis and counterfactual analysis and gripping the entirety of the ecosystem. Therefore, they are more prone to coming up with scaremongering. Or they're going to look and see that they're not jurisdictions that are necessarily originating the innovation anyway. And most of these emerging markets are either using copycat innovation, or they're simply using the products of that innovation, but they're not in a position to compel some of the entities that are engaging in innovation-intensive products. That's going to be quite an interesting ride, and I think we're at the beginning of that kind of a ride because more and more emerging market competition authorities are engaging with digital market players, and they're requesting changes in their products, and they're meddling with product design. And obviously, this is therefore going to be a particular area of interesting observation in the future.
Okay, thank you very much. Thank you.
There's just a small point,
yeah.
Frédéric, if I may, that I'd like to make. This is not only an issue of competition law. I just want to highlight that. So while we're speaking in the area of data protection, in the area of internet law, in the area of freedom of speech, which contents should be removed, which contents are of freedom of speech, which are inciting imminent lawlessness, and all kinds of local law concepts. These are also subject to the same kind of question marks. Some countries are even mandating some of these companies to definitely find a subsidiary in their land. Turkey is trying to walk that line at the moment so that they have a counterpart because they don't know how to deal with digital counterparts and all that. I'm just throwing it in there as an additional note that while competition law and merger control is dealing with these matters, because a lot of these companies actually in their corporate governance structure amount to people living in California in their flip-flops and not having that many other assets or servers or entities elsewhere in the world. It does come down to basically how do we enforce law in general, not only merger control, about these companies that are able to export such a great mass of content and influence all over the world. So it's beyond the merger control bit, I believe.
It includes merger control, but it's not limited
to merger control. Yes. Yeah. I was just gonna say, I do agree that also among the emerging market regimes, there are some that are extremely burdensome in their procedural requests. Luckily, the Turkish authority is not one of them. And during the pandemic, actually, they even gave up on the apostillation and notarization requirements on powers of attorney, realizing that that's also a COVID-related issue, and notaries and apostillation authorities don't work in most countries. But a lot of institutions haven't been this forthcoming with their relaxation of the requests, and some of them have used it to actually control how much application they get. I think the problem is a problem of transparency. Marine didn't put it that way, but I think part of the issue that one stumbles upon in emerging markets is emerging markets are generally less used to keeping their bureaucratic steps transparent, and there are surprises a little too frequently, and that's how things work. And in more developed economies and in more developed markets, there is more transparency. It's a whole different conversation, and Fred and I, we had this conversation at the OECD before, but there is a correlation, obviously, between these two. So the more transparency you have and the more freedoms you have, the more developed your economy is as well, but that's a whole different topic. Ultimately, though, the emerging markets of today are generally not extremely foreseeable in their handlings of files, and surprises can happen more frequently. When you also put, for example, I'll give the example of Ukraine, for example, when you put also certain countries in the mix where they're really asking for everything to be apostilled and gazillions of procedures to be kicked in, this is also forbidding, much like maybe even more so than a filing fee. And then entities start dodging these countries. They start with an analysis of what happens if we don't notify there. And once they start with that, they start actually shedding more and more of the emerging markets as well, regardless of whether they're doing a good job or not. So that is a problem. I think that is an issue for fora like OECD and ICN to take on. I know that the OECD and the ICN are trying to make sure that there are best practices of authorities, but there are a lot of habits, also sworn translation request habits and all that. And honestly, I've been doing this for 23 years. There are people that have been doing it for many more decades than I do. I'm not so sure that they're reviewing these documents. So you actually are going through a lot of pain to provide these annexes that don't seem to be reviewed. And there could be some efficiency attained if a supranational body were to look into an NGO, NGA type of hybrid were to look into this matter and provide advices to authorities to not overcomplicate things beyond what's necessary.